I never thought I would end up in a legal battle with my homeowners association over something as simple as getting a mandatory property inspection. But here I am, sitting in my living room with a stack of legal documents that could wallpaper my entire house. My name is Ethan Holbrook, and I have lived in the Meadowbrook Estates subdivision in Scottsdale, Arizona for the past 3 years. When my wife Sarah and I first bought our house here, we thought we had found paradise. The community was beautiful, the homes were well maintained, and everything seemed perfect. We knew there was a homeowners association, but we figured it would just handle basic things like maintaining the common areas and making sure nobody painted their house neon green. Boy, were we wrong. The trouble started about 6 months ago when the HOA board changed leadership. The new president was a woman named Brenda Patterson, a 52-year-old real estate agent who seemed to view the position as her personal fiefdom rather than a service role. Within weeks of taking over, she had implemented a dozen new rules, increased dues by 30%, and started sending violation notices to homeowners for the most ridiculous infractions imaginable. One neighbor got fined because his mailbox was the wrong shade of black. Another received a citation because her rose bushes were 3 inches taller than the newly established height limit for front yard vegetation. I managed to stay off Brenda's radar for the most part by keeping my head down and following every absurd rule to the letter. My grass was always exactly 2.5 inches tall, my house number was the approved font and size, and I parked both vehicles in my garage every single night. I thought I was safe. Then came the letter from the city building department. Arizona has strict regulations about residential electrical systems, and our neighborhood had been built in the late 1990s, which meant many homes were due for mandatory electrical safety inspections. The letter explained that a licensed inspector would need to access my property within 30 days to examine the electrical panel, wiring, and various connections throughout the house. Failure to comply could result in fines and potentially even having my power disconnected until the inspection was completed. I called the number provided and scheduled the inspection for a Tuesday morning in March. The inspector, a guy named Robert Chen, seemed professional and accommodating. He said he would arrive between 9 and 11 in the morning and that the inspection typically took about 2 hours. I took the morning off work, made sure the house was clean, and prepared all the documentation he might need. Tuesday morning arrived with perfect Arizona weather, sunny and 75 degrees. I had my coffee and waited. Around 9:30 my phone rang. It was Robert. "Mr. Holbrook, I am outside your neighborhood, but I am having an issue getting to your property," he said, sounding frustrated. "What kind of issue?" I asked, already feeling a knot forming in my stomach. "There is a woman here who says she is with the HOA and she has blocked the entrance to your street with her vehicle. She is refusing to let me through." I felt my blood pressure spike. "I will be right there." I grabbed my keys and drove the 1/4 mile from my house to the neighborhood entrance where my street branched off from the main boulevard. Sure enough, there was Brenda Patterson's white Lexus SUV parked diagonally across the entrance to Sycamore Lane, completely blocking access. Behind her was a white van with Phoenix Metro Building Inspection Services written on the side. Robert Chen was standing next to his van, looking equal parts annoyed and bewildered. Brenda stood in front of her Lexus with her arms crossed, wearing a floral print blouse and white capri pants, her blonde hair styled in that signature Karen cut that seemed to give people like her their power. "Brenda, what are you doing?" I demanded as I parked my car and got out. "I am protecting our community," she announced, as if she were defending the gates of heaven itself. This unauthorized vehicle cannot enter our neighborhood without proper HOA approval and scheduling. He is a city inspector, I said, trying to keep my voice level. I have a mandatory inspection scheduled. You cannot block him from doing his job. All service vehicles must be pre-approved by the HOA board, Brenda recited, clearly quoting from some rule she had probably written herself. This includes contractors, deliveries, and yes, inspectors. You failed to submit Form 7B at least 72 hours in advance. I stared at her. Form 7B? I have never even heard of Form 7B. And this is not a contractor, this is a city official performing a legally mandated inspection. Rules are rules, she said with that particular smile that people use when they think they have won an argument. The HOA has the right to control access to our streets. This is private property. Robert Chen stepped forward, pulling out his identification. Madam, I am a licensed building inspector working on behalf of the city of Scottsdale. I need to access this property to conduct a mandatory electrical safety inspection. You are currently obstructing a city official in the performance of his duties. I am protecting property values, Brenda shot back. We have procedures for a reason. Mr. Holbrook should have followed the proper channels. What proper channels? I nearly shouted. You made up a rule about a form that nobody knows exists, and now you are physically blocking a city inspector from doing a legally required inspection. Do you realize how insane this is? Watch your tone with me, Brenda snapped. I can have you cited for harassment of a board member. Several other neighbors had started to gather, drawn by the commotion. Tom and Jennifer from 3 houses down came walking up, along with old Mr. Martinez from the corner house. Even Patricia, who usually avoided any kind of conflict, had ventured out to see what was happening. Brenda, you need to move your car, Tom said. He was a lawyer, and even though he practiced corporate law rather than anything relevant to this situation, his professional voice carried weight. You cannot block city officials from performing their duties. Stay out of this, Tom, Brenda said. Unless you want to find yourself cited for those bushes that are encroaching on the sidewalk in front of your house. I turned to Robert. I am so sorry about this. What can we do? He sighed and pulled out his phone. I am going to have to call my supervisor and report this obstruction. This is going to need to be documented. You do that, Brenda said smugly. And I will be documenting that Mr. Holbrook invited an unauthorized vehicle onto HOA property without following proper procedures. The streets are public right-of-ways, Tom interjected. The HOA does not own them. We maintain them, Brenda countered. And our CC and Articus clearly state that the HOA board has authority over access and use. While they argued, Robert stepped away and made his call. I could hear him explaining the situation to someone on the other end, his voice professional but clearly annoyed. After a few minutes, he came back over. My supervisor is contacting the city attorney's office, he said. They are also notifying code enforcement. Madam, he addressed Brenda directly. I am officially informing you that by blocking my access to perform a mandatory safety inspection, you are in violation of Arizona Revised Statutes Section 11-808, which prohibits interference with building inspectors performing their lawful duties. You need to move your vehicle immediately. I am not moving until Mr. Holbrook produces the proper documentation, Brenda said, doubling down on her absurd position. There is no documentation required, Robert said, his patience clearly wearing thin. This is a city-mandated inspection. The HOA has no authority to prevent it. We will see about that, Brenda said, pulling out her own phone. I am calling our HOA attorney right now. This was getting ridiculous. I looked at my watch. It was already 10:15. The inspection was supposed to be finished by noon so I could get to work for an important afternoon meeting. Now, we were standing in the street having an absurd standoff because Brenda Patterson had decided to flex her perceived authority. More neighbors had gathered, and the consensus seemed to be that Brenda was completely out of line. Even Gladys Walters, who was normally one of Brenda's allies on the board, looked uncomfortable with the situation. "Brenda, honey, maybe you should just let the inspector through," Gladys said carefully. "This seems like it might be causing more trouble than it is worth." "Absolutely not," Brenda said. "If we let one person skip the procedures, then everyone will think they can do whatever they want. This is about maintaining order and property values." "This is about you having a power trip," Patricia muttered, loud enough for everyone to hear. A few people chuckled, which only made Brenda's face redder. A Scottsdale police cruiser pulled up about 10 minutes later. Officer Davis, according to his name tag, got out and assessed the situation. Robert explained everything to him while Brenda tried to interject with her version of events that somehow made her sound like she was protecting the neighborhood from some kind of invasion. "Madam, you need to move your vehicle," Officer Davis said after hearing both sides. "You are blocking a public right-of-way and interfering with a city inspector." "This is private HOA property," Brenda insisted. "No, madam, this is a public street," the officer corrected her. "The HOA may maintain it, but it is a public right-of-way. You are in violation of City Ordinance 321, obstruction of a public thoroughfare. I am giving you one warning to move your vehicle. If you refuse, I will cite you and have your vehicle towed." For a moment, I thought Brenda might actually refuse and get herself arrested right there in front of the whole neighborhood. I could see her weighing her options, her jaw clenched tight. Finally, with obvious reluctance, she got into her Lexus and moved it to the side of the road. "This is not over," she said to me as she got out of her car. "You will be receiving a violation notice and a fine for this unauthorized access." "Do what you want," I said, exhausted by the whole ordeal. "Can we please just get this inspection done?" Robert followed me back to my house, apologizing profusely even though none of this was his fault. The inspection itself went smoothly. My electrical system was in good shape, with just a few minor recommendations for upgrades that I could handle whenever convenient. Robert completed his work by noon, provided me with the official inspection certificate, and left with his own apology for the drama. I thought that would be the end of it. I was wrong. 2 days later, I received a certified letter from the HOA. Inside was a formal violation notice citing me for unauthorized vehicle access without proper board approval, along with a $500 fine. The letter referenced the mysterious Form 7B that I was supposedly required to submit at least 72 hours before any service vehicle entered the community. I called an emergency meeting with Tom, who agreed to look over my HOA documents and CC an architect. We spent an entire evening going through every page of the covenants, conditions, and restrictions, as well as all the amendments and rule changes that had been implemented over the years. "There is no Form 7B, Tom said finally, looking up from the stack of papers. "More importantly, there is no rule requiring advance notification for service vehicles. She made this up." "Can she do that?" I asked. "Technically, the board has the authority to implement new rules, but they have to follow proper procedures. New rules have to be proposed, reviewed, voted on by the board, and then communicated to all homeowners at least 30 days before they take effect. She cannot just invent a rule and start enforcing it immediately." "So what do I do?" "First, you are going to write a formal letter disputing this fine, and citing the lack of any such rule in the official HOA documents. Second, you are going to request a hearing before the board. Third, you are going to start documenting everything, because I have a feeling this is just the beginning. Tom was right. The next week, I received another letter from the HOA, this time informing me that my dispute had been reviewed and denied by the board. The fine was now increased to $750 due to continued non-compliance and failure to acknowledge rule violations. I was furious. I had done absolutely nothing wrong. I had complied with a mandatory city inspection. And now, I was being fined an increasingly ridiculous amount of money because Brenda Patterson had invented a fake rule to punish me for making her look bad in front of the neighborhood. I hired an attorney, a woman named Rachel Klein who specialized in HOA disputes. She was in her late 30s, sharp as a tack, and had a reputation for not taking any nonsense from overreaching HOA boards. "This is one of the more blatant cases I have seen," Rachel said after reviewing my documents. "She blocked a city inspector, got called out by a police officer, and is now retaliating against you with fake fines. We have multiple causes of action here." "I just want this to go away," I said. "I do not want to be in some lengthy legal battle." "I understand, but sometimes these things need to be addressed head-on, or they just get worse," Rachel explained. "Brenda Patterson has demonstrated that she is willing to abuse her authority. If you let this go, she will continue to do it to you and probably to other homeowners as well." She was right. I had already heard through the neighborhood grapevine that Brenda had started citing other people for increasingly bizarre violations. Someone got fined because their guest parked on the street for more than 4 hours. Another homeowner was cited because their American flag was supposedly the wrong size, even though it was a standard 3 by 5 foot flag that had been there for years. Rachel filed a formal response to the HOA on my behalf, along with a demand that they provide documentation of the rule I had supposedly violated, proof that the rule had been properly implemented according to the CC and Articus, and evidence that all homeowners had been notified of this rule at least 30 days before enforcement began. She also included a letter noting that the HOA board president had obstructed a city official, and that I was prepared to provide testimony to the city regarding that incident if necessary. The response came back within a week. The HOA attorney, a guy named Richard Sterling, sent a letter that basically ignored all of Rachel's points and instead argued that the HOA board had broad discretionary authority to maintain community standards, and that my fine was appropriate and justified under the circumstances. "They are not even trying to defend the specific rule," Rachel noted. "They are just asserting authority and hoping you will back down. This is actually good for us because it shows they have no legal basis for the fine." We requested a formal hearing before the HOA board, which was our right under the CC and Articus. The hearing was scheduled for a Thursday evening in mid-April at the community clubhouse. Rachel prepared me for what to expect, warning me that these hearings were often hostile and that the board usually stuck together regardless of the merits of a case. The clubhouse was packed when we arrived. Apparently, word had spread throughout the neighborhood about the dispute, and people were curious to see how it would play out. I saw Tom and Jennifer, Patricia, Mr. Martinez, and probably 24 other residents, all crammed into a room designed to hold maybe 50 people comfortably. The board sat at a long table at the front of the room. Brenda was in the center, flanked by Gladys Walters and 3 other board members whose names I could never remember. They all looked uncomfortable except for Brenda, who had that same smug expression she had worn when blocking the inspector. The hearing began with Brenda reading a prepared statement about the importance of rules and community standards. She went on for probably 10 minutes about property values and uniformity and respect for authority. Finally, she got to the actual issue. Mr. Holbrook violated clearly established procedures by allowing an unauthorized vehicle onto HOA property without proper advance notification and approval, she said. This violation warrants the assessed fine of $750, which must be paid within 30 days or will be subject to additional late fees and potential lien placement on the property. Rachel stood up. "May I respond?" "You may," Brenda said, looking annoyed that I had brought an attorney. "Thank you. First, I would like to request that the board provide a copy of the rule that my client allegedly violated, specifically this Form 7B that he was required to submit." Brenda shuffled through some papers. "It is in the Community Standards Manual." "I have a complete copy of the Community Standards Manual, dated and provided by the management company," Rachel said, holding up a thick binder. "There is no mention of Form 7B anywhere in this document. Could you please provide the specific page number where this requirement appears?" The board members looked at each other. Gladys leaned over and whispered something to Brenda. "It was in the updated manual," Brenda said. "When was the manual updated?" Rachel asked. "Recently." "Specifically when?" "I do not have the exact date in front of me." "That is fine, I will wait while you look it up," Rachel said pleasantly. Brenda's face was getting red again. She whispered something to the board member on her right, who shook his head. Finally, she looked back at Rachel. "The update was implemented in February." "February of this year," Rachel clarified. "Yes. And when were homeowners notified of this update?" "It was posted on the community website." "The CC and Articus require 30 days written notice for any new rules that carry fines or penalties," Rachel said. "Was written notice provided to all homeowners?" Silence. The answer was clearly no. "Furthermore," Rachel continued, "the vehicle in question was not a contractor or service provider in the traditional sense. It was a licensed city inspector performing a mandatory safety inspection required by law. The HOA has no authority to prevent or delay legally mandated inspections." "We have authority over access to community streets," Brenda interjected. "The streets are public right-of-ways, as confirmed by the Scottsdale police officer who responded to the incident," Rachel said. "The HOA maintains them, but does not own them and cannot restrict access by government officials performing their duties. In fact, by physically blocking the inspector's vehicle, the board president violated Arizona Revised Statutes Section 11-808 and was warned by a police officer that she would be cited if she did not move her vehicle. My client did nothing wrong. He complied with a mandatory city inspection. He is not required to seek HOA permission to comply with the law." The room was completely silent. Brenda looked like she wanted to explode. The other board members looked like they wanted to be anywhere else. "The board will deliberate and provide a decision within 10 business days," Brenda finally said through clenched teeth. "One more thing," Rachel added. "If this fine is not rescinded immediately, we will be filing suit against the HOA and individually against the board members for harassment, abuse of authority, and retaliatory conduct. We will also be providing detailed testimony to the city regarding the obstruction of a city inspector, which may result in additional legal consequences for the individuals involved. I strongly encourage the board to make the right decision." We left the clubhouse to scattered applause from some of the homeowners in attendance. Tom caught up with me in the parking lot. "That was amazing," he said. "Brenda looked like she was going to have a stroke." "I just want this over with," I said honestly. "It will be," Tom assured me. There is no way they can uphold this fine after that. Rachel destroyed them. The 10 business days came and went with no communication from the HOA. Rachel sent a follow-up letter demanding a response. Finally, on day 14, a letter arrived. The board had voted 3-2 to uphold the fine, with some additional language about how they were being generous by not increasing it further for my disrespectful conduct during the hearing. "They are insane," I said to Rachel over the phone. "They are stubborn, which actually works in our favor," she said. "We now have clear grounds for a lawsuit, and given their complete lack of legal basis for the fine, we will probably win and recover our attorney fees. But there is something else we need to discuss." "What?" "The inspector, Robert Chen, actually filed a formal complaint with the city about the obstruction. The city attorney's office has been investigating, and they want to talk to you about what happened." 2 days later, I sat in a conference room at the Scottsdale Municipal Building with Rachel, an assistant city attorney named Mark Brennan, and Robert Chen. I gave a detailed account of everything that had happened on the morning of the inspection, and Robert corroborated the story. Mark took notes and asked several clarifying questions. "This is problematic," Mark said when we were finished. "We take obstruction of building inspectors very seriously. These inspections are critical for public safety. If HOAs or anyone else think they can block inspectors from doing their jobs, it undermines the entire system." "What happens now?" I asked. "We are going to issue a formal citation to the HOA and to Mrs. Patterson individually for obstruction. There will be fines, and if she does this again, there could be criminal charges. We are also going to send a notice to every HOA in Scottsdale clarifying that they have no authority to prevent or delay building inspections." "Will that help with my situation?" I asked. "It should," Mark said. "Once the HOA receives the city citation and fine, they will probably be more inclined to resolve your dispute. No HOA wants to be in a fight with the city." The city citation arrived at the HOA management office about a week later. The fine was $2,000, payable to the city of Scottsdale, for obstruction of a city official performing lawful duties. Brenda Patterson was named individually in the citation, along with the HOA itself. The neighborhood erupted. People were talking about it at the mailboxes, at the community pool, at the nearby coffee shop. The general consensus was that Brenda had finally gone too far and needed to step down. An emergency HOA board meeting was called. I was not sure what was discussed because it was a closed session, but rumors flew. Some people said Brenda refused to resign. Others said the other board members were trying to force her out. Gladys Walters resigned from the board entirely, reportedly saying she wanted nothing to do with the situation anymore. Meanwhile, Rachel filed our lawsuit against the HOA in Maricopa County Superior Court. The complaint laid out everything: the fake rule, the obstruction of the inspector, the retaliatory fines, the failure to follow proper procedures, and the continued harassment despite clear evidence that I had done nothing wrong. We sued for damages, attorney fees, and an injunction preventing the HOA from continuing to enforce the fake rule or fine me. The HOA's attorney, Richard Sterling, reached out to Rachel about a week after the lawsuit was filed. He wanted to discuss a settlement. Rachel and I met with him at his office in downtown Scottsdale. "Look, this has gotten out of hand," Richard said. He looked tired. "I have advised the board multiple times that they need to drop this, but Mrs. Patterson has been resistant. However, in light of the city citation and now the lawsuit, I think I can get them to agree to rescind the fine and reimburse your attorney fees." "That is a start," Rachel said. But my client also wants a formal apology and assurance that there will be no further retaliation. I can probably get them to agree to no further action, but I do not know about an apology, Richard said. Then we will see you in court, Rachel said, standing up. Wait, Richard said. Let me talk to them. Give me a few days. Those few days turned into 2 weeks. During that time, several more things happened. First, a local news station got wind of the story and did a segment about HOA overreach that featured interviews with me, Robert Chen, and several of my neighbors. Brenda refused to be interviewed, but they showed footage of her house and noted that she had declined to comment. The story went semi-viral online, with thousands of people sharing it and commenting about their own HOA horror stories. Second, several homeowners in the neighborhood filed a petition to recall the entire HOA board and hold new elections. They needed signatures from 30% of homeowners to trigger a recall vote, and they got that within a week. Third, the city of Scottsdale sent out the promised notice to all HOAs in the city, explicitly stating that HOAs have no authority to prevent, delay, or restrict access by city inspectors, and that any interference would result in citations and potential criminal charges. Finally, Richard called Rachel with a settlement offer. The HOA would rescind all fines, reimburse my attorney fees up to $10,000, provide a written statement acknowledging that I had not violated any rules, and agree to a consent decree prohibiting them from implementing any new rules without proper notice and procedure. In exchange, I would dismiss the lawsuit. What about Brenda? I asked Rachel. She is not going to apologize, Rachel said. But honestly, I do not think she is going to be board president much longer anyway. The recall vote is next month, and from what I hear, she is going to lose badly. I agreed to the settlement. The lawsuit was dismissed, and I received a check from the HOA for my attorney fees along with a formal letter stating that I had not violated any community rules and that all previous violations had been rescinded. It was not everything I wanted, but it was enough. The recall vote happened in late May. I had never seen such turnout for an HOA election. Usually, maybe 20% of homeowners bothered to vote. This time, over 70% showed up or submitted ballots. The entire board was recalled, including Brenda Patterson. A slate of new board members was elected, including Tom and Patricia from my street. Brenda tried to give a speech at the meeting where the recall results were announced, but she was basically shouted down by angry homeowners. She and her husband put their house on the market the following week and moved out of the neighborhood by the end of June. I heard they relocated to Surprise, Arizona. I hope their new neighborhood's HOA is more to their liking. The new board's first action was to repeal about half of the absurd rules that Brenda had implemented, including several that nobody had even known existed. They also hired a new management company and implemented a more transparent process for rule changes that required input from homeowners. But the story does not end there. In late July, I received a call from Mark Brennan, the assistant city attorney. I wanted to update you on the citation we issued, he said. The HOA paid their fine, but Mrs. Patterson refused to pay hers individually. She claimed she was acting in her official capacity and therefore should not be personally liable. What does that mean? I asked. It means we are taking her to court. We cannot let people think they can just refuse to pay citations for interfering with city officials. The hearing is scheduled for August 15th. We may need you to testify if she contests it. August 15th fell on a Friday. Rachel agreed to come with me to the hearing even though she was not officially representing me anymore. The hearing was in Scottsdale Municipal Court, a small building near the Civic Center. Brenda was there with a different attorney, not Richard Sterling. This lawyer was younger, maybe in his 30s, and he looked like he knew he had an uphill battle. The city presented its case first. Mark Brennan called Robert Chen to testify about the obstruction. Robert gave the same account he had given before, describing how Brenda had blocked the street with her vehicle and refused to move despite being told she was interfering with a mandatory inspection. "Did you explain to Mrs. Patterson that this was a mandatory city inspection?" Mark asked. "Yes, multiple times," Robert said. "I showed her my credentials and explained that Mr. Holbrook was required by law to have this inspection completed." "And how did she respond?" "She said she did not care, that she had authority over the streets, and that the inspector needed HOA approval before entering the community." "Did you explain that the HOA has no authority to prevent city inspections?" "Yes, I did. She insisted she was right." Next, Mark called Officer Davis, the police officer who had responded to the scene. He testified about arriving to find Brenda's vehicle blocking the street and Brenda refusing to move despite being told she was in violation of city ordinances. "Did you warn her about the consequences of continuing to obstruct the inspector?" Mark asked. "Yes, I told her she would be cited and her vehicle would be towed if she did not move immediately." "And did she move?" "Eventually, but only after I made it clear I was serious about the citation and tow." Finally, Mark called me to testify. I described the entire morning, including Brenda's insistence on this fake Form 7B and her refusal to let the inspector through, even after multiple people explained she was wrong. Brenda's attorney tried to argue that she had been acting in good faith to protect the community, and that she genuinely believed the HOA had authority over street access. He painted her as a dedicated volunteer who had made an honest mistake. The judge, a woman named Judith Morrison who looked like she had been on the bench for a few decades and had seen everything, was not buying it. "Counselor, your client was told by a licensed inspector, by multiple homeowners, and by a police officer that she had no authority to block the street," Judge Morrison said. "At what point does good faith become willful obstruction?" "Your Honor, Mrs. Patterson was following what she believed to be HOA rules and procedures," the attorney argued. "Rules that she apparently made up herself and that have no basis in the actual HOA governing documents," the judge said dryly. "I have reviewed the complete case file, including the subsequent lawsuit and settlement. This was not a good faith error. This was an abuse of authority. The citation is upheld. Mrs. Patterson will pay the $2,000 fine plus court costs. Furthermore, I am placing her on probation for 1 year. If she engages in any similar conduct during that period, she will face criminal charges for obstruction." "Do you understand, Mrs. Patterson?" Brenda stood up. She looked like she wanted to argue, but her attorney put a hand on her arm. "Yes, Your Honor," she said quietly. As we left the courthouse, Rachel turned to me. "Well, that is about as definitive as it gets." "Is it really over?" I asked. "It is really over." I went home that afternoon feeling like a weight had been lifted. Sarah, who had been supportive through this entire ordeal even though it had stressed both of us out considerably, opened a bottle of wine to celebrate. "No more HOA drama," she said, raising her glass. "I will drink to that," I said. The rest of the summer passed quietly. The new HOA board was actually functional and reasonable. They focused on actual community maintenance rather than harassing homeowners over trivial violations. Tom, as one of the new board members, made sure that all the rules were clearly documented and that homeowners were properly notified of any changes. They even created an online portal where people could easily submit requests and track any issues with their properties. Several of my neighbors thanked me for standing up to Brenda. Apparently, a lot of people had been living in fear of her arbitrary enforcement and ridiculous fines, but nobody wanted to be the one to challenge her. My fight had freed everyone else. In October, I had to have my HVAC system inspected, another city requirement for older systems. I scheduled the inspection and informed the HOA through the proper channels, though Tom assured me it was not necessary for city inspectors. The inspection went smoothly, with no blocked vehicles or confrontations. The inspector, a different guy this time, actually commented on how pleasant and accessible the neighborhood was. "You would not believe some of the places I have to go," he said. "HOAs can be a nightmare sometimes. This one seems fine, though." "It is better now," I said, and left it at that. I ran into Brenda's husband, David, at a hardware store in November. He was civil but clearly embarrassed. We made small talk about the weather and avoided any mention of what had happened. I heard through mutual acquaintances that their marriage had been strained by the whole incident, with David reportedly furious that Brenda's behavior had forced them to sell their house and move. The holidays came and went. The new HOA board organized a neighborhood holiday party that was actually fun instead of feeling like a mandatory appearance at some authoritarian regime's celebration. People actually seemed to enjoy living in Meadowbrook Estates again. In January, almost a year after the whole ordeal started, I got a call from a local news producer. They were doing a follow-up story on HOA reform and wanted to know if I would be willing to be interviewed again. "We have been hearing that the state legislature is considering new laws to prevent HOA overreach," the producer explained. "Your case has been cited as an example of why these reforms are needed. Would you be willing to talk about your experience?" I agreed, and a few days later I was back in front of a camera describing everything that had happened. The story aired in February, almost exactly 1 year after Brenda had blocked Robert Chen's vehicle. The piece discussed proposed legislation that would more clearly define the limits of HOA authority, require more transparency in rule-making, and create an easier process for homeowners to dispute fines and violations. All of this started because one homeowner refused to accept an unjust fine, the reporter said in the closing segment, with a shot of my house in the background. His stand against HOA overreach may end up protecting homeowners across the entire state. It was surreal to think that my frustrating experience with a power-hungry HOA president might actually lead to meaningful change. Rachel called me after the story aired to say that she had been contacted by several state legislators who wanted to discuss the proposed reforms. The legislation passed in March, with strong bipartisan support. The new law required HOAs to provide clear, written notice of all rules at least 60 days before enforcement could begin. It established a formal dispute resolution process that did not require homeowners to hire attorneys just to fight bogus fines. It explicitly prohibited HOAs from interfering with government inspectors or emergency services. And it created real penalties for board members who abused their authority, including personal liability for fines and potential removal from their positions. Tom sent me a text when the governor signed the bill. "You did this. Everyone in every HOA in Arizona owes you a debt of gratitude." I did not know about that, but I was glad something good had come out of such a frustrating experience. Sarah and I celebrated with dinner at our favorite restaurant, the same place we had gone to celebrate buying our house 3 years earlier. "You ever regret moving here?" She asked over dessert. "Not anymore," I said honestly. It was rough for a while, but it is good now. The neighborhood is great, the HOA is functional, and we have a nice house. And you are a local hero, she teased. I am not a hero, I just refuse to pay a fine I did not deserve. That is exactly what a hero does, she said. They stand up when something is wrong, even when it would be easier to just go along with it. I thought about that on the drive home. I had not set out to be anyone's hero or to change state laws. I had just wanted to get a mandatory inspection done without being hassled by an overzealous HOA president who thought she could make up rules and push people around. But by refusing to back down, by hiring an attorney and fighting back, I had not only resolved my own situation, but had helped protect countless other homeowners from similar abuse. The Meadowbrook Estates neighborhood thrived under the new board. Property values actually went up, contrary to Brenda's dire warnings about maintaining her iron-fisted control. People took pride in their homes because they felt respected and valued, not because they were terrified of arbitrary fines. The community events were better attended because they were actually enjoyable rather than obligatory exercises in proving loyalty to the board. I never saw Brenda Patterson again after that day in court. I heard occasional updates through the grapevine. She supposedly tried to get involved with her new HOA in Surprise, but was met with immediate suspicion when people Googled her name and found all the news stories about the Meadowbrook Estates incident. She eventually gave up and kept a low profile. Robert Chen and I actually became friendly. He sent me a thank you card after the municipal court hearing, expressing gratitude that the city had taken the obstruction seriously, and that there would now be clear precedent for dealing with similar situations in the future. We got coffee a few times, and he shared some truly unbelievable stories about HOAs and their attempts to interfere with building inspections. Mine was bad, but apparently some HOAs had actually tried to prevent inspectors from citing homes for serious safety violations because they did not want the neighborhood to look bad. The thing people do not understand is that these inspections exist for a reason, Robert explained. We are not trying to harass homeowners or find petty violations. We are making sure houses are safe. Electrical fires, gas leaks, structural failures, these things kill people. When an HOA interferes with an inspection, they are literally putting lives at risk for the sake of maintaining some image of perfection. That perspective made me even more grateful that I had fought back. It was not just about my specific fine or Brenda's abuse of power. It was about protecting a system that existed to keep people safe. In April, I was invited to speak at a state HOA management conference about the importance of following proper procedures and respecting homeowner rights. It was surreal standing in front of a room full of HOA board members and management company representatives, many of whom probably viewed me as the enemy. But I tried to frame it constructively. I am not anti-HOA, I told the audience. I understand that HOAs serve an important purpose in maintaining communities and protecting property values. But that purpose is undermined when board members abuse their authority or make up rules without following proper procedures. The reforms that passed this year are not an attack on HOAs. They are a protection for homeowners and for well-run HOAs that do follow the rules. Because every time a board member acts like Brenda Patterson, it makes all HOAs look bad and makes homeowners distrustful of the entire system. The response was mixed. Some people seemed genuinely interested in learning from the situation. Others looked defensive and hostile. But at least the conversation was happening. That summer, Sarah and I hosted a barbecue for the neighborhood. It was a beautiful June evening and probably 40 people showed up. Kids played in the pool while adults chatted and ate burgers and drank beer. Tom gave a toast, thanking everyone for their support during the recall election, and promising that the new board would continue to prioritize transparency and fairness. "And a special thanks to Ethan," Tom added, raising his beer toward me, "for having the courage to stand up to injustice and for making this neighborhood a better place for all of us." Everyone applauded, and I felt genuinely touched. A year and a half earlier, I had been standing in the street arguing with a woman who had blocked a city inspector's vehicle with her SUV. Now, I was surrounded by neighbors who had become friends, living in a community that actually functioned the way an HOA was supposed to function. As the evening wound down and people started heading home, Patricia came over to thank Sarah and me for hosting. "You know, I almost moved when Brenda was in charge," she confided. "I could not stand the constant stress of wondering what I would be cited for next. My recycling bin was the wrong color. My doormat was too large. My Christmas lights were up 2 days past the deadline. It was exhausting. You saved this neighborhood, Ethan. I really mean that." After everyone left, Sarah and I sat on our back patio watching the sun set over the desert landscape. "Worth it?" she asked. "Definitely worth it," I said. Looking back, I could have just paid the initial $500 fine. It would have been easier and less stressful. I would not have had to hire an attorney, endure a hostile HOA hearing, file a lawsuit, or testify in municipal court. But I also would have validated Brenda's abuse of power and set a precedent that would have emboldened her to continue harassing other homeowners. Sometimes the easy path is not the right path. The inspector incident became something of a legend in Meadowbrook Estates. New residents would hear the story and express amazement that it had actually happened. Existing residents would occasionally reference it when discussing HOA matters, usually as a cautionary tale about what happens when board members forget they are supposed to serve the community, not rule over it. As for me, I went back to my normal life. I went to work, spent time with Sarah, maintained my house, and participated in neighborhood activities. The HOA sent out their monthly newsletters and collected their dues and handled maintenance issues, all without drama or arbitrary enforcement of fake rules. It was boring in the best possible way. Sometimes I would drive past the spot where Brenda had parked her Lexus diagonally across Sycamore Lane, blocking Robert Chen's inspection van. It was hard to believe that such a ridiculous confrontation had spiraled into lawsuits and city citations and state legislation. But that is how change often happens, not through grand planned movements, but through ordinary people refusing to accept injustice in their daily lives. I never set out to be an HOA reform advocate or a local news story or an example cited by state legislators. I just wanted to get a mandatory electrical inspection done without being harassed by an overreaching HOA president. But by standing my ground and refusing to accept an unjust fine, I ended up protecting not just myself, but potentially thousands of other homeowners across Arizona. The new state law went into effect in July, almost 18 months after the initial incident. The Arizona Department of Real Estate, which oversees HOAs, sent out information packets to every registered HOA in the state explaining the new requirements and procedures. I received a copy in the mail, and reading through it felt like vindication. Every provision addressed something that had gone wrong in my situation. The requirement for clear written notice, the prohibition on interfering with government officials, the formal dispute process, the personal liability for board members who abused their authority. Rachel called me when she received her copy. "You should be proud," she said. "This is going to help a lot of people." I just hope it prevents others from going through what I went through, I replied. It will, and even if it does not prevent every case, it gives homeowners tools to fight back. Before this law, people like you had to hire attorneys and file lawsuits just to challenge an unjust fine. Now there is a formal process that does not require thousands of dollars in legal fees. That was perhaps the most important part. Not everyone could afford to hire an attorney like I had. Many homeowners would have just paid Brenda's bogus fine because fighting it was too expensive and time-consuming. The new law leveled the playing field at least somewhat, giving ordinary homeowners a realistic way to challenge abuse without having to take out a second mortgage. By the time fall arrived, everything had settled into a comfortable routine. The HOA functioned smoothly under Tom and the rest of the new board. My electrical system remained in good working order following the inspection that had started the whole mess. Brenda Patterson was presumably living her life somewhere in Surprise, hopefully having learned something from the experience, though I was not optimistic about that. Sarah and I started talking about maybe having kids in the next few years. The neighborhood would be a good place to raise a family, we agreed. Good schools, safe streets, plenty of other families around. The kind of place we had hoped Meadowbrook Estates would be when we first bought our house. Just promise me one thing, Sarah said. What is that? If we ever move and buy a house in another HOA neighborhood, you will do thorough research on the board before we make an offer. I laughed. That is a promise I can definitely keep. In December, I received an invitation to speak at a national HOA management conference in Phoenix. The organizers had read about the Arizona reforms and wanted me to share my perspective on the importance of balanced HOA governance. I almost declined, feeling like I had said everything there was to say on the subject, but Rachel encouraged me to accept. You have a platform now, she said. Use it to keep pushing for better practices. So I flew to Phoenix and gave another speech about respecting homeowner rights while still maintaining effective community management. The audience was larger and more diverse than the state conference had been, with attendees from across the country. The questions afterward were more thoughtful too, with people genuinely wanting to understand how to avoid the kind of situation that had occurred in Meadowbrook Estates. One woman raised her hand during the queue and a session. What would you say to board members who are trying to do the right thing but feel caught between angry homeowners and the need to enforce rules? I would say focus on the purpose of the rules, I answered. Rules should exist to maintain property values and create a pleasant community, not to give board members power over their neighbors. If a rule does not serve a legitimate purpose, it should not exist. And if you are making up new rules, follow the proper procedures and give people adequate notice. Most of the problems in my situation came from the board president inventing a rule out of thin air and trying to enforce it immediately. That is not fair to anyone. Another person asked, "Do you think the Arizona reforms go too far in limiting HOA authority?" No, I think they establish appropriate boundaries, I said. HOAs still have plenty of authority to maintain communities and enforce legitimate rules. What they cannot do anymore is act arbitrarily, make up rules without following procedures, or interfere with government officials. Those are not limitations on legitimate HOA functions. Those are protections against abuse of power. The conference organizers thanked me afterward and said my remarks had been well received. Several attendees approached me to share their own HOA horror stories, both as homeowners and as board members who had tried to rein in overzealous colleagues. It was clear that the issues I had experienced were not unique to Meadowbrook Estates or even to Arizona. HOA overreach was a problem across the country, and while I could not fix everything, At least I had helped address it in my own state. The year ended on a peaceful note. Sarah and I spent Christmas in Meadowbrook Estates. Our house, decorated within the reasonable HOA guidelines that had replaced Brenda's absurd requirements. Tom and Jennifer hosted a New Year's Eve party where we toasted the end of a tumultuous period and the beginning of what would hopefully be a calmer chapter. As midnight approached and we counted down together, I reflected on everything that had happened. A routine inspection had turned into a confrontation, then a legal battle, then a policy reform, and ultimately a restoration of sanity and fairness in how HOAs operated. It had been stressful and frustrating and expensive, but it had also been worthwhile. The clock struck midnight and everyone cheered and hugged and toasted the new year. Sarah kissed me and whispered, "To no more HOA drama." "I will definitely drink to that," I replied, and we clinked our glasses together. 2 years after the inspector incident, life in Meadowbrook Estates was better than it had ever been. The neighborhood had actually grown closer as a result of the shared experience of dealing with Brenda's tyranny, and then rallying together to elect a better board. We had community barbecues and movie nights and volunteer landscaping days. Property values had indeed increased, not because of aggressive enforcement of petty rules, but because people genuinely enjoyed living there and took pride in maintaining their homes. I occasionally thought about Brenda and wondered if she ever reflected on what had happened. Did she understand that her abuse of power had backfired spectacularly? Did she regret blocking that inspector's vehicle, or did she still believe she had been in the right? I would probably never know, and ultimately it did not matter. What mattered was that the system had worked, at least eventually. Justice had prevailed, reforms had been implemented, and the community had emerged stronger. The inspector incident would always be part of Meadowbrook Estates lore, the story that new residents would hear and find hard to believe. But it would also serve as a reminder of why HOA governance matters, why homeowners need to pay attention to who serves on their boards, and why standing up to injustice, even over something as seemingly small as a bogus $500 fine, can make a real difference. As I sat on my back patio one evening, watching another spectacular Arizona sunset, I felt genuinely grateful for everything that had happened. Not grateful for the stress and conflict, obviously, but grateful for the outcome. Grateful that I had the resources to fight back when others might not have. Grateful for the attorney who believed in my case. Grateful for the neighbors who supported me. Grateful for the inspector who filed his complaint with the city. Grateful for the legislators who turned a local dispute into meaningful statewide reform. Most of all, I was grateful that when faced with an unjust situation, I had chosen to fight rather than submit. That choice had made all the difference, not just for me, but for countless others who would now be protected by stronger laws and clearer procedures. Sometimes one person standing up really can change things, even if that person is just a regular guy who wanted to get a routine inspection completed without being harassed by his HOA president. And that, ultimately, is the lesson of the whole experience. Change does not always come from politicians or activists or organized movements. Sometimes it comes from ordinary people who simply refuse to accept injustice in their daily lives, who say no when someone abuses their authority, who stand their ground even when it would be easier to back down, who turn personal frustration into collective action and lasting reform. I never expected to become an HOA reform advocate. I just wanted to live in my house peacefully and not get fined for things I did not do. But life has a way of taking us in unexpected directions, and sometimes the detours, however frustrating, lead to destinations worth reaching. Meadowbrook Estates was now one of those destinations, a community where people felt safe and respected and valued, where the HOA served its proper purpose without overreaching its authority, and where everyone remembered the inspector incident as a turning point that made everything better. As the sun dipped below the horizon, and the desert sky turned from orange to purple to deep blue, I raised my glass in a silent toast to Robert Chen, to Rachel Klein, to Tom and all my supportive neighbors, to the legislators who passed the reform bill, and even to Brenda Patterson, whose overreach had inadvertently sparked positive change. Then I went inside to be with Sarah, grateful for our home and our community, and the hard-won peace that now defined our lives in Meadowbrook Estates.